Are you good now, Robin?
Yes, I'm good.
Ah, I know you're good. I should have asked a different way. Shouldn't I? Oh, lousy.
I
Okay,
got you.
okay. You got your South Carolina hat on today? Because you almost always have your South Carolina hat on
I
working in.
have to, don't I?
Yeah, you have to switch gears when you go home. Well, the good thing is we don't have too many new forms on the South Carolina side. However, interestingly enough, I did just see that they're going to remove some forms. And one of the forms that they're going to remove would affect you as a listing agent in South Carolina. They are going to remove the form that says rejection offer, and requesting multiple offers. I guess it was 2 years ago, maybe 3 years ago now, the South Carolina Association, excuse me, the South Carolina lawmakers produced a form called rejection of offer. And that rejection of offer is to be filled out by listing agents anytime they get an offer, whether it's multiple offers or any offer that is rejected by the seller. That form must go back to the buyer's agent, and that's form 314. There was already a form 312, as you can tell by the numbers, one that was done previous to that 314 being instituted by the lawmakers. The Realtors Association had produced this rejection of offers and requests for additional offers or new offers. This was basically to take care of the multiple offer situation. And I did not see an explanation as to why, other than they're saying they're deleting that form. And I suppose that it's causing too much conflict between the one that the lawmakers produced versus the Realtor Association. All that to say that form 312 is going away. Okay. Then there's two forms that are going away and that have to do with this, the contingency, the buyer sale contingency. And I know you said, well, we're talking about listings today, but you as the listing agent need to know which of these forms that you accept and which you don't, and know that you won't accept some of them. So when you get an offer to purchase, which they call agreement to buy and sell, and your seller does not accept any of the terms of it, you sign that I should have pulled that form up, I didn't, the form 312. And also keep in mind on that form, that is a form for you as an agent to sign, where you are confirming that you indeed did present that offer and the seller rejected it. You cannot even add the seller's signature to confirm. Isn't that interesting?
I always wondered about that, especially this multiple offer situation we had. Was my offer as a buyer's agent, even was my offer actually presented? How did we know for sure? So that's
I've had other people say that, you know, they wondered about it. So now you know, and like I said, I think the seller ought to have to sign it, you know, quite honestly. But the lawmakers said no, that you cannot require them to sign it because they rejected the offer. And as far as they're concerned, they're done. Okay. So now can you see my my forms, or do you just see me?
We just see you.
Okay, that's what I was thinking. Okay, I see the forms, but okay, let's see here. Now we see each other and we see the forms, right? Robin, can you see the forms?
Yes, ma'am. I got you.
Phew, all right, Lashonda, can you see? Lashonda can't have with her volume, so she can't tell me. But I think if you can see if she can. So this obviously is our little multicolored checklist. checklist that is here is really kind of like a worksheet, just a guide, as you all have already seen and know. You obviously have a checklist that's in your DocuSign when you're putting your documents in. So you have one there. We have multiple checklists, but this one is updated with the forms that you would be using right now. As you know, the forms do not change every year or on any regular schedule in South Carolina. Any given month, they could be different, or they may be the same for 7 years. So you will not see a copyright date go to 2022 on all of their forms. In fact, I don't think I've seen any copyright 2022 except the new form that they just implemented. So as you can tell in here, we basically have the form number, and we have the date that the form was copyrighted or implemented. We're going to kind of work through the listing agreement and the South Carolina side. Now there will be occasionally a difference, and LaShonda has membership in the Columbia MLS. So remember, LaShonda, the coming soon or the firm office exclusive would be different out of that MLS, because those are MLS forms. The ones that I have in this stack of forms obviously would be the ones that would be for Canopy. So every now and then if you are a member of a different form of MLS and you have listings in that area, just watch those MLS forms, because they could and will be different. Okay. And of course you would not do the Canopy forms because you're going to do them in that area. Now, as I said, on this form, you basically, it's a little worksheets, kind of like a map for you, some of the different forms that you'd use. The last version that I did on this was in June of 2022, because that was the last date we had some form changes. Remember, in June 13th? Well, I don't know why they did it on the 13th. It was an arbitrary number, but that was when some of the forms changed. So we will look at those today, a few of them, but most of them are for buyers, so we won't address them as much. Don't know why I put that blank page in there, but anyway, you got a free page. Let's talk about the exclusive right to sell. But before I do, you know what I have to say, because this is what you have to say. Let me tell you how we work as a real estate agent in South Carolina, right? That's the first thing we have to do. We have to present that disclosure brokerage of brokerage relationships in South Carolina. I did not put one in the stack of forms. I should have. I know to do that, but I wanted to get right on to the forms that we use in depth. The disclosure, South Carolina disclosure brokerage relationships must be presented before you go into a listing agreement or any other type of an agreement with the client. So I'm not going to go through that today because we've done it before. I know you two know how to do it. We're still having some challenges on our listing agreements as to term dates and marketing dates, and when can we put in coming soon, or do we put it in coming soon? So we're going to kind of hone in on that just a little bit today. Okay. I had a highlighted version that I kind of wanted us to look at so that we can get a better grasp of that clear cooperation policy. You know, the clear cooperation policy, when it was implemented in May of 2020, it caused a lot of concern because it was such a stark imposition into our business, because it basically said that we had to put all of our listings into the MLS as within one business day, and within that one business day, that basically that's kind of hard to do because obviously we have to get things ready to go into MLS, and you don't just sit down and fill in 10 fields. There's a lot of stuff that you've got to have prepared before you make it active in MLS or even under the coming soon. And those of us who practice a lot in North Carolina have seen a difference versus the way it's done in South Carolina. So when you're thinking about when to put it on the market, when is the term going to begin in South Carolina as to when you can sell the property, that's the deciding factor. And that basically is the first thing that pops up right up here. Once you put in the name of the firm and the name of the seller, then the first thing you've got to decide is when is the when is the date that you can do anything with that property. As we've said before, a contract's not a contract if you don't have a beginning date and an end date. You've got to know the term. When does it begin and when does it end? So in South Carolina, if for whatever reason you sign the agreement on, let's say, I've used this date of October 15th. Let's say you did it on October the 10th. You signed the exclusive right to sell, or you and the seller did. But the term is not going to be start until October the 15th. During those 5 days, it's like a ghost listing. You cannot tell anybody about it. You cannot discuss it. It is to give the seller 5 more days to finish painting the mailbox or changing the front door or doing those last minute things that they've got to do in order for you to start marketing. Now, South Carolina for this whole time, 2 years, has felt that putting it in MLS is marketing. It's not marketing to the public, but it is marketing, but we're marketing it as coming soon. So North Carolina is just now catching up to that, to be honest with you. But South Carolina has, for the very beginning, said, if you put the beginning term on the date that you sign, which we call the effective date, if you make it the beginning of the term the same as the effective date, then you have 1 business day to get it into MLS, either as active or as coming soon. So what they have recommended is to delay the term beginning date, and a few days it would be fine to do it. There are some people that want their house marketed, they wait on the MLS tomorrow because you signed the agreement today, right? Yes, ma'am.
I'm so sorry to interrupt. Something's come up and I'll have to get off, but I'll jump back on in about 30 minutes.
Oh, okay, honey.
I'm so sorry.
All right, I understand.
All is good.
We'll see you when you get back. Okay.
I'll be right back.
Okay, honey. Bye-bye. LaShonda and I will continue on. So if you delay that, I mean, if your seller says, no, I want you to get somebody in here tomorrow, then your only option would be to put the term date as tomorrow. And you stay up all night long getting all the information in MLS. Hopefully, you've had a few days to start your inactive listing, because you can put it in as inactive and start filling in all the blanks on your listing. So hopefully you've had a little time to do that, so that if the seller does say, I want it marketed immediately, then you can make it go active, or convince the seller that it's important to have this coming soon time, and it'll be marketed, but it will be marketed as coming soon. And that coming soon rider has to be on the sign. That's coming soon phrase has to be on anything that you put out there, whether it's a Facebook ad or whether or not it goes into MLS, it goes in as coming soon. So be careful with the term coming soon, with just saying coming soon. It's really coming soon, no show. And so to be able to be accurate and to continue to create the consequences of having it coming soon, the consequence of coming soon gives you time to get your measurements, gives you time to get pictures. It gives you a little lead time, which is the way it was designed. However, it must be not shown, okay? The no-show is as critical to convey as the fact that it's coming soon. Coming soon is really good marketing tactic, but the no-show is really the clincher. It's not that you can't disclose information. If it's in coming soon, then you can disclose any information you want to, whereas you cannot if it's previous to the date that you put right here where it's beginning. So to recap, we said we're going to have the effective date as October the 10th. That's the day everybody signs it. We're not going to mention that listing to anybody because our term does not begin, let's say, till October the 15th. On October the 15th, you are either going to put it in MLS as active or as coming soon, but you are going to put it in MLS on that date. All right. And here's your end date. Let's say that it's going to end to February the 28th, 2022. Because we've already way past that. I need to update my dates, don't I? So that you got your term. Now, having said those dates, let's go see what we have to do in order to put it in MLS on October the 15th. If we are not going to go firm exclusive, excuse me, if we're not going to go active, we've got two choices. We've got going in is coming soon or firm exclusive. Now, in this particular listing agreement, let's scooch on down here and take a look at it. I believe it's paragraph, is it 12 or 13? Hold on a minute. 13. I should remember that. If you are going to put it in active or coming soon, this is the option you're going to check. On October the 15th, you are going to do one of those statuses. If you're not going to put it in MS at all, then you're going to come down here and choose this option. And our MLS form is called firm exclusive. That's the form you're, and we're going to look at that in just a moment. So this is the firm exclusive. If it's not going to go in MLS, but as of October the 15th, you can start marketing it within your firm. You cannot talk to anybody outside of your firm about it. So that would be your firm exclusive. This is the option we're going to look at first, because right now we're saying we do not want to make it active as of October the 16th, which is the business day, one business day. Now you will make sure that you put check one of these boxes. It says the owner agrees that broker may compensate an agent representing the buyer from the fee described in paragraph 3. The owner agrees or does not agree that the listing will be placed in electronic marketing mediums, including but not limited to the internet, MLS Internet Data Exchange, which is the IDX, or any other program. This is where they give you permission, basically, to have it in MLS. You can't put it in MLS if it's not agreed by the seller to have these electronic means of syndicated disclosure, not disclosure, advertising. So keep that in mind. So you always want to get the agreement, otherwise you can't put it in MLS, you know. So you're kind of up a creek if they don't agree. Now let's take a look at this coming soon agreement. That's the MLS agreement, and that's what I told you, LaShonda, might be different in the Columbia market or one of the other markets that you work in. Let's see, where did it go? What's over here? Okay, here's your coming soon. This is the Canopy coming soon form. And you can see right here where they put it in capital letters and put it in red to make sure that brokers know that it may not be shown. All right. If it's a little difference here again, LaShonda, you'll remember that the new thing in the triad, they have made it very clear that it's not to be shown, and they're only going to let the coming soon be in effect for 7 days. That has not trickled down to any of the other MLSs that I know of yet. It certainly is not the case in Canopy. You can still keep the listing in coming soon for 21 days. Most people do not use it for 21 days, but that's the maximum time. I think it's a really interesting twist that the Triad now has changed to, and Triangle has now changed to 7 days. Otherwise, it's an immediate fine of $1,000. I think it's also interesting that Triad has now said not only will the listing agent face $1,000 fine, so with the selling agent, the buyer's agent, if they show a property during the coming soon. I think that's a really good addition to a possible fine. Okay, so just be aware of the differences in these different MLSs. Now, when you come down here to the blank on the coming soon, where it says marketing and active dates, this would be in South Carolina, it would be the term date. Okay, and right here is the date that it's going to be active in MLS. You're going to put it in MLS and coming soon, and whatever date is here is the date that it's going to be up. It's going to be, the status is going to be changed from coming soon to the active date. Because if you go in as coming soon here, you start your marketing, that's the term date that you have up on page 1. We just talked about that, October 15th. Then how many days are you going to leave it in coming soon before it goes active? This is the date that in Triad could be no longer than 7 days. In Canopy, it can be up to 21 days. All right. So this is the marketing date, and that date is not listed in the South Carolina listing agreement, whereas it is in North Carolina. You have the term date when it's going to go into the MLS, but this is the only place that you note when it's going to go active in MLS in South Carolina. As you will note, and I know you've already used these forms, so this is not totally new to you. You have initials on just about every blank in there. I mean, every provision anyway. So this is make sure that the seller knows that the seller can't show it either. The seller can't show it. The painter can't show it. The stager can't show it. Nobody could let anybody else in with the prospect of viewing at that home. And so you want to point that out. You want to make sure having their initials so they are saying, yes, my agent told me that. Again, they highlighted this in red, that it is in the best interest of the seller to allow it to be exposed to all agents in MLS and on the open market. So they are making sure that we see this in red, that the seller understands that that offer they got from the neighbor down the street may or may not be their best offer. And statistics show that the better offer is going to come from someone having been exposed broadly, throughout all of the public. So again, they highlight that in red, and you want to get your initials there. So each section is a section for you to explain or describe what is going to happen with being in the coming soon status. Most of us use coming soon as a teaser in the market, and it gives us time to get our photos and stuff that we need to get done. So, but make sure the seller understands why it's important probably to use that coming soon. The seller is not penalized by it not going out in the syndications or going out for people to see. It's just that the property can't be shown and you can't take an offer. Now on the coming soon form here, you're wanting to get your property address. There are 4 signatures on, well, maybe 4, up to 4, I guess, on both the coming soon and the firm exclusive. You want to put the property address here, your seller's signature. If there are more than 2 sellers, you will have to add an extra page, blank page, and making an addendum to this agreement. We do not have, in South Carolina, we do not have an additional provisions, additional signatures form. And in MLS, we don't, okay? But the two I wanted to point out to you is you would sign it as the listing agent. You are not the member participant. The member participant is the broker in charge of the firm. So the broker in charge of the firm needs to know that you're putting it in coming soon, to be able to watch and make sure you advertise it correctly, first of all, but to be in agreement with the seller that that's how you're going to market it. So anytime you see the word member participant, that's going to be your broker in charge. All right. So you're going to send that to the broker in charge, which happens to be me right now. When you have your forms in DocuSign, you can order the way they are signed. There is no reason for me to sign it until the sellers have signed and until you have signed. And this needs to be done at the same time. Your coming soon addendum and or your firm exclusive, whichever one you're going to use, those need to be done at the same time. These are not forms that you do the coming soon because you're going into coming soon, then later on do other forms. This is part of your listing package. You might even have both coming soon and firm exclusive in your template, and then knowing which one you're going to do, you're going to eliminate one of them. So, but what I wanted to make sure is you understand it needs to be done at the same time. I really should be looking at your listing agreement to see that the dates. Carla does that for us, but my signature does have to go on here and should be the same date. I should not be getting this 6 or 7 days after you've done the listing. Yes, we're seeing that in some folks. So we're going to lean in on some teachable moments here. It should be done at the same time. The critical one, however, that needs to be done at the same time is the firm exclusive. Now let's go take a look at it. The format is very similar to the coming soon. The main difference on the excuse me, the firm exclusive is that it is only advertised in our firm. If you have one conversation with one agent outside of our firm, it is no longer allowed to be under firm exclusive. There's a fine if you do that, and it immediately has to go active. You lose the right to firm exclusive. So remember, when you're talking about your listings to people, do not talk to an agent outside of Keller Williams Valentine if it's under this firm exclusive agreement. Now, obviously, it's written out here for you to have that understanding and talk to your client. The thing I wanted to point out most to you here, just like the other agreement, there's a lot of seller's initials that they understand. Right down here, seller does or does not authorize the listing brokerage to enter the listing into the MLS system. After it closes, a firm exclusive listing can be entered for comparisons. You know, obviously we all look for comps in the MLS. So in order to have a better data base of solds in a neighborhood, they are allowing us to put the information off of a firm exclusive in for comps only. But you have to get the permission of the seller. There are some sellers who really don't want their information as public information. You know, yes, there's ways to find it out from the tax records, but as far as having it in MLS, you have to have the permission. Now, again, that's one of the critical things that I have to see is if they do or they don't, then you would be the one who actually enters the data, but you have to have this authorization to do it. Now, what I have to do is look down here where it says signature of the brokerage member participant. Again, remember, that's the broker in charge. So when you are getting the signatures on your listing agreement, you want to have your first one as the order of the signing should be one of the sellers, the other seller, the listing agent. You can go ahead and sign it. It's okay if you sign it and send it out to them. Okay, but do not send it to me to be signed and then send out to them. It needs to go, best order would be seller sign it, listing agent sign it. I should be the last one who signed it, but I must sign it within 2 days or it's invalid. All right. That signature must be on that listing agreement, firm exclusive tied to that listing agreement within 2 days of the seller signing. Again, if you send it to me 5 days late, it's of no value. It really is of no value. And at this particular time, they're not finding us, but what they are requiring is once I get that within 2 days, 2 business days, I have to register it. I have to submit it to the MLS so that they know we do have a legally binding, valid listing agreement that we have the right per the seller not to put in MLS. So if somebody in the community, it's usually another agent, wants to find out information about they've heard it's for sale, then they're going to contact MLS. MLS has this database set up with all this information in it, not of the property, but the fact that we have a listing there. So that's critically important. Now we do have, we try to keep a list of all the firm exclusive, and hopefully the agents are marketing among other agents in the market center when they have a firm exclusive. You can put that on the Valentine Facebook page, the one that's the official Valentine KW Valentine. You can put it on your own Facebook page. You cannot interact with other firms on it. Is the clincher. Okay. There are times, let's say, there's a realtor in the neighborhood who knows that house is for sale, and that realtor calls you and wants to know more about your listing. If you start talking to them, you have to disclose to them, first and foremost, that you're not going to talk about the listing because it's a firm exclusive listing and you're not authorized to talk to them about it. However, if they persist that they've got another neighbor who wants to buy it, then you go back to the seller and explain to the seller that there is someone who would be wanting to see the property who is represented by another firm, and therefore the seller has to make a decision. The seller has to make a decision whether or not they're going to terminate the firm exclusive agreement in MLS and put it active in order to show it to this other person or the neighbor. And it's a gamble either way. It really is. Sometimes it works out really well. They think they kind of like the idea of just working with one person. Hopefully that person will be generous and give them a good offer. And you already know the sales price. So if you take it down that track, remember, you have to terminate the firm exclusive. Now in North Carolina, to terminate the firm exclusive, you'll remember we use the Form 710. They do not have an amendment to a listing agreement in South Carolina. So you cannot use 390 because that's an amendment between the buyer and the seller. You have to go back to the original listing agreement. Now I'll show you that, but before I leave, one more time, I want to remind you to set that order of signatures when you send that listing agreement and all the documents that go with it. Make sure that I'm the last one who signs it, and I being the last one who signs it better be within 2 days of when the seller signs it. All right, now let's scooch on back up here and take a look where I was going to show you that where you could cancel, where you can terminate. This is the last page of the listing agreement under provision number 28. we have added here, this is just, again, my notes to remind us. If it's going to be under coming soon status, you want to add that for form. Or if it's going to be under firm exclusive, you're going to add that for form when you submit it. If during the term you find out that you no longer want it to be firm exclusive, you are going to make it coming soon or active, which would be if the neighbor wants to see it, you would obviously go active. Then you're going to have to terminate this one right here. So you would strike through this and make a note that the listing will be made active in MLS on such and such a date. And rather than being in a separate form, you're going to do it right here on this form here. I wish there did have an amendment form, but they being the form writers in South Carolina feel that it's better to have it all on one agreement rather than have an amendment. So anytime you have a change of price, if you extend the listing, if you change a date in your listing agreement for whatever reason, maybe that term date, the seller wasn't ready to go on the market on October the 15th. He wanted October the 17th. Then you have to go back in there and strike through and add the initials for the seller and for you as the listing agent, because there was a change. Similarly here, if you strike through this and say that this agreement is being terminated and the listing will go active in MLS, then you're going to type that in there. That's a change, obviously. So you're going to have initials by each of the sellers and by you and by me. Okay. Let's go back up here now to, I guess, and please, if you have any questions, let me know. Okay. Raise your hand. And I'm trying, you know what, LaShonda, it doesn't show me. Oh yeah, I do. I see the chat up at the top instead of the bottom to see if you put in any other question. I'll try to keep an eye out for it. That's where you said that you are following it, and you do not want that $1,000 fine. I don't want you to have it either, darling. Okay, let's see. Let's go back up at the beginning. We didn't get very far from that first paragraph, did we? We basically were talking about this October the 15th. Now, in this description here, your description most of the time is going to come from the tax records. All right. Every now and then they're wrong. And we have found 2 or 3 in Lancaster County, not recent months, that there were some discrepancies. So be careful with if you can find a copy of the deed, make sure the deed matches what the tax records say. But most of the time you can rely on what the tax records say to fill in the tax information. Now, tax map number is what we would refer to as parcel ID. Remember, you have to put the parcel ID when you're entering it in MLS, and that's that little hyperlink up at the top right hand side that'll take you directly from the number into the actual tax record. And so that's a real good feature for us, but make sure you get the right number. Okay, so tax map number is what we refer to as parcel ID number. Now, let's look at this little paragraph right here. Lord have mercy. You can't imagine all that's packed into that one little sentence that barely goes on to the second line. All right. There is so much packed into that. One of the things that we often refer to as fixtures, they have one word for fixtures, and that's fixtures. And it's like, well, who says what's a fixture? There's no definition of fixture. It's not even taught of what is a definition of fixture in the South Carolina pre-licensing. One teacher who taught for many years explained to me one time, she said, well, what I tell my class is if I turn the house upside down and shake it, what sticks is a fixture and what drops off is not a fixture. And I said, well, that at least gives me a middle picture. If it's a fixed to the degree that didn't fall off, I guess it could be a fixture. So because of the discrepancies and conflicts and fussing that we get into sometimes, the Vic down at in Fort Mill, the Baxter location, she and I basically got the attorney down there to draft this fixtures addendum, which outlines, and you will notice it's very similar to the North Carolina list at the time he drafted it several years ago, but at least it gives you a talking point. So now I did include one of those in case you haven't seen it. It is way on down here. Let's see where I put it. There's where I put it. Very last one. If you go as the listing agent through these items, it's an educational time for your seller too. See, the seller sometimes doesn't know what a fixture is either, and the seller doesn't know a lot of what's expected to be left. Okay, so if you want to use this as a teachable moment, but I would suggest that you add it as an addendum to the contract so that you have an understanding when you start talking and negotiating the agreement to buy and sell, you know what your listing contract or your listing agreement says that the seller will or will not leave. I don't think that we have it on this particular addendum because at the time the attorney put this together for us, storage sheds were not a fixture in North Carolina. They are now a fixture. If you'll remember looking on that, okay, maybe it's page 3 of the offer to purchase, a storage shed is a fixture. It doesn't matter what size it is. It doesn't matter the value. It doesn't matter anything about the foundation. For years, it depended on whether or not the foundation of it was concrete or permanent. It is storage sheds or fixture. In South Carolina right now, would you believe it is not a fixture? Okay. However, there is some evidence that it is an appurtenant structure, which means it's attached to the ground. So I'm not so sure. We might not have to get this fixtures addendum amended and to add that, but just be aware of it. So when you are talking to the seller, you need to know what the seller's plans are for that storage shed. That she shed may not be able to stay. If so, be clear in your disclosure of it. So right here, it says where the seller does not intend to convey, even though storage shed is not listed, you would make sure on here that the storage building is not going to convey. All right. So that's one of the things you want to kind of keep in mind when you're going through the house to make sure that you are guiding. You have to really be a leader in the listing agreements, because they don't know a lot of these ins and outs. And you say, well, I don't know either, I'm new. Well, you're learning them, okay? And so that's why you're in class today. I know y'all are diligent. So make sure that if for whatever reason they have a shed, find out if they're leaving it or not. Sometimes they have a favorite rose bush. You know, grandmother gave me that rose bush and I have nurtured it now for 25 years and I want to take my rose bush with me. That's okay, as long as they put it right here, the rose bush does not stay. And I would suggest, if you have such a situation, that you take a Ziploc bag and put one of those little green ties and put it on that rose bush that says does not convey, so that the buyer knows instantly that certain plants are not going to stay. You don't see an awful lot of that, but you do see it occasionally. Now, this part here about they're not leased or not owned by the seller. If it's like a propane tank, you know, if you've been in the North Carolina listing class a couple of weeks ago, I think you were, make sure that the fuel tank is a real big issue right now in North Carolina. We're not seeing it as such a big issue in South Carolina. The tank typically that's leased is the propane gas tank. and that propane gas tank is being leased, you need to find out what's involved in the lease, what would be involved in transferring it. So if your seller has a leased anything, whether it's security system accessories, it may be a satellite dish, most of those are staying anyway, or a fuel tank, see right here, make a note of that. Again, use these forms as worksheets and educational tools in addition to pulling together the legal agreement. Now on the bottom here, the seller would sign this because you are representing the seller. If you make it part of the offer to purchase, then you could ask the buyer to sign it. Because this is an in-house form, you cannot require another party to sign it, but I want you to teach the sellers and I want you to disclose to the buyer. It's up to them whether or not they're going to sign it, but it should be if it's a part of the agreement. Therefore, they're on the same page and you're not going to have those arguments at the closing table, okay? Now let's scoot on back up here to the listing agreement. Here we are. This lot that's described in parcel ID or tax map number, it's land, real property, real land that has some improvements, most likely a house of some kind on it. It has fixtures, which we're going to define in our fixtures addendum. The appurtenances would be anything attached to the ground, okay? Or any additional property. Additional property sometimes is the lot, an adjacent lot. They decided, you know, they wanted some space bigger than their lot, so they bought the lot next door. You must identify that lot if it's a separate parcel ID. When the property is sold, you might have some issues with the lender if that's vacant land. So just be aware that if there is additional property, that you identify it and identify it by parcel ID if one is available. All right, when we go into this little section here, the consent to disclose dual agency or designated agency, this is where you start talking to them again. And you say, remember when we were talking about the brokerage relationships and the disclosure early on, which I didn't give you the copy, but you say, remember when we talked about that? This is what this is about. First of all, I want you to initial right here, Mr. Seller, that we talked about that disclosure. This is where you get his initials. Then here, this again is different from the way you get it done in your North Carolina listings. This is the permission to consider, or the seller is going to say that he will consider giving you permission to act as a dual agent or act as a designated agent. It is not him agreeing to it. It is not him agreeing to either one of them, but it is that he said, okay, I understand the importance of it. So, but I will consider it. Now, when you are talking to him about that, you want to come down here and have these forms available. He's not to sign these forms at this time, but you want to show them to him. These are forms, the dual agency. Notice this right here. This is the seal of South Carolina. That means the lawmakers designed this form. This form was not designed by the South Carolina Realtor Association. Remember a while ago, I was telling you about Form 312 and 314. 312 would not have that seal on it, whereas 314 would, okay? So back to the dual agency now. That seal says, the lawmakers say this has to be presented to a client, a person who is going into an agreement. The dual agencies doesn't change all that much because agency it's a law basically from the land. It's a law of agency. It's a contractual law. So the dual agency would be between the seller and the firm. The firm can be a dual agent, or the sub-agents of the firm, you being the primary one right now, would be the subagent of the firm could be an individual dual agency. You have dual agency when the firm represents both sides of the transaction, and or an individual subagent of the firm represents both sides of the transaction. The variation from that is something called designated agency. It's a variation of dual agency. You can't have designated if you don't have dual, all right? If the firm is a dual agent and you as a subagent of the firm do not represent the buyer, but you are representing the seller, and we have another subagent of the firm representing the buyer, that's dual agency designated. You would be designated to take care of the seller exclusively. The buyer agent would be designated to take care of the buyer exclusively. Therefore, y'all have your parties have representation, although it is underneath the firm being a dual agent. Now, you have two forms. This is your dual agency for the individual or the firm. Then you have the second form that looks, again, very similar. And this is your designated agency agreement. This outlines it verbally and in legalese so that a person understands it. Hopefully you understand it from my explanation. When a buyer's agent that would be affiliated with Keller Williams Ballantine, only Keller Williams Ballantine, we are not in agency with any other Keller Williams office or any other office, all right? We are in we would be in an agency relationship. If you have the listing and let's say Robin is representing the buyer, and so LaShondra has the listing and Robin's representing the buyer, both of you are Keller Williams Ballantine agents. So at that point, when Robin writes the agreement to buy and sell, she is going to attach this document, this designated agency. And you can see right here, the associated licensee's supervisory broker is me, Sabre Romeo, or whoever your Vic is at the time. Then LaShondra's name is going to go right here. Robin's going to put it in there. Robin's going to put her name representing the buyer. She's going to have the buyer sign this agreement because it's going to go with the agreement to buy and sell. Robin's going to sign it down here because she's the associate licensee, but Keller Williams Ballantine here. That form must go with the agreement to buy and sell. So when you, LaShondra, receive this agreement to buy and sell offer from Robin and her client, then you should have this designated agency form that goes with it. And then your seller can sign it because they have considered, they have been willing to consider dual agency, designated agency. You will not put them or commit them into that situation without disclosing it to them. That's where the term disclosed designated or disclosed dual comes in. You're telling them about it now, but you will come and you can give them a copy of this form. I don't mind, but tell them you will come back to them before you present the agreement to buy and sell the offer for them to consider the offer. You will let them make the choice at that time whether to sign this form for designated or dual. Okay, I know that can get confusing, and hopefully that'll explain a little bit more these forms. Again, the forms can be shown to the seller at this point, but I generally do not leave them. Generally just show them there is a form and we will address it later. What you have to have now is, are they dead set against the firm being a dual agent, you being a dual agent, or you being a designated agent? Then if they are, then they're going to have to check this one right here. Don't know why those boxes, there should be 4 boxes here. I don't have that. I need to go check that in the newest edition. But anyway, this is where right up front, you're going to know how you can sell this property. All right. And if you have the right to work beyond the single agency as a listing agent. The terms, obviously, you write out right across here, just like a check. You're going to put the sales price, or the list price, rather it is. You're going to write it out verbal in words. Then you're going to come in here and write the dollar amount in numbers, just like, again, like you would write out a check. This paragraph is about what you're going to get paid. You're going to be paid in a percentage, not a dollar amount. Our firm does not do what you call fee for service. Our firm does not do transaction brokerage, where you just take care of the paperwork with no representation to the person involved. You're not going to put a dollar amount. That's going to be always a zero. A percentage is what we would obviously prefer would be what we've done for eons of years. In my 40 years of business, it's been 6%. Now looky here, see that word right there, it says total. This is the total amount of commission the seller could expect to pay. And using 6%, then you would put 6% here. Then you want to show him in the next page, when you come down here, how much you're going to share if another broker is involved in the transaction. In other words, and as you'll notice right here, you see where I put all these blanks. We're only going to cooperate with buyer agents. I just mentioned a moment ago, we do not cooperate with transaction brokers, nor do we cooperate with someone from another firm being a sub-agent for our seller. We are the sub-agent, all right? So in MLS, by the SA, that's going to be a 0. By the TB, it's going to be a 0. But by the BA, which buyer's agent, we will participate, cooperate, and using what has been pretty much the going rate, 3%. So if you got a total of 6, you're going to give away 3. That leaves you 3, right? Do not put 3 up here and then come down here and put 3, because you've just given away the entire commission. So make sure this one is the total. Out of the total, we're going to share with the buyer agent the percentage that you and the seller agree on. Now, we are seeing a lot of this differential treatment of this particular scenario. In fact, just this morning, I had an agent contact me, and the cross-sell agent, buyer's agent from another firm, was asking for an increase on the amount of buyer's agent commission that the seller and she had put in MLS. I believe in that particular situation, they had 2%. And having 2% being given to the buyer's agent proposed to our agent that if she was getting 6%, he wanted 3%. So we had quite a discussion about it. Listing agents many times are finding they're spending some pretty good money right now on particular professional photographs and measuring and all the different types of marketing they're doing. So they feel justified that they should earn a little bit more than the buyer's agent. A buyer's agent does not agree. A buyer's agent said, but you don't know how many offers I've had to write for this buyer. I've had to write 8 offers, and we still haven't gotten one through. So buyer's agents are working hard and spending time. They might not be paying an invoice for pictures, but buyer's agents are earning their keep these days. So you kind of have to look at it both sides. So having said that, if you choose and your seller chooses not to give you 6%, because the sellers are, they're kind of watching their dollars as well. And so they may say, well, I'm only going to pay 5 or 5.5. Now, if you want, and if you want to give 2.5 to the buyer's agent, that's fine with me, because the seller is concerned about the total amount, not so much how much you're going to cooperate. For years, we have said, if we don't give 3% to the buyer's agent could, and we hesitate to use this word, steer. They might think another listing might be better for their client. And we're not saying they're really steering, but they can have some influence. Okay. That is not as true right now as it was for years, the last few years. And now it is probably more likely you're going to see 2.5% than 3. And you'll see that 2.5% where the seller or listing agent might be getting 3.5. Okay. And there are some firms who actually get higher amounts and share lesser amounts. That is not, you don't see that much in the marketplace. So just kind of talk through some of those issues, some of the scenarios with your seller, get your seller's agreement as to how much they want to share of your commission. And again, put the total amount here, total percentage, and a percentage here for what you're going to share. Let's go down here. It's probably a good time to address the fact of earnest money. It might not be that you go into too much detail, other than to say that in South Carolina, there is no clear-cut definition anywhere in their agreement to buy and sell as to who gets the earnest money. They can breach the contract, and it's still not clear in the agreement to buy and sell who gets the earnest money. So help the seller to understand that most likely he can't count on getting earnest money, but he does have equal opportunity to agree or disagree on earnest money. Because in South Carolina, the only way earnest money is released is by agreement by the parties or by the court order. So if the seller does not agree, he has a right to express that not agreeing, but he also has the right to go to court to settle the earnest money. So make sure, the only thing you kind of have to watch for, again, this is a sidebar, is in South Carolina going to court over the earnest money, the maximum amount is $7,500. So if I were you, I'd put it in the back of my mind, I would never want earnest money to be over $7,400. Oh yes, we've had one of those cases. It was $10,000 and it had to go to civil court, and it was nasty. So from then on, I'm thinking, don't ever do an earnest money that's more than 75. Even if you do 74.5, I don't care, but don't make it over 75 or over. Okay, back to the contract. Right here, it is in bold print and capitalize what I just said. The earnest money will not be released until both parties have executed a written agreement authorizing release or a court of competent jurisdiction. This is the provision that gives you the right to put a sign in the yard. Remember, if you have a firm exclusive, there is no sign in the yard. Okay. If you are incoming soon, a sign may be put in the yard, but it must have the rider that says coming soon. If it goes active, there could be a sign in the yard. Be reminded that you cannot have an open house if it's in coming soon, and do not put an open house sign out there with a coming soon rider. One of my agents did that. She got taken to the board on I believe it was an ethics charge. I forgot what they charged, but she wound up having to pay $500 because that was misleading to the public to say open house, which you're inviting them in, but you're saying coming soon. And that was misrepresentation of what the open house sign was about. So again, all that to say, do not do open house signs. You can do yard signs and say coming soon. All of this is outlined basically what your duties are. I would take a little highlighter or something and just kind of briefly go through some of these, and you decide which ones you want to emphasize. Down here, the seller's duties. See this little section right here? To permit the broker to incur expenses. For a while, we were seeing people overseas that would want the broker to be responsible for having the yard cut, you know, the landscaping trimmed, and the broker was paying the landscaper to do that. You don't need to do that anymore. I really didn't recommend it at that time, but every now and then, you know, it was expedient for a broker to take care of it. Now with Venmo and PayPal and all the other electronic means, there is no reason a seller cannot pay invoices. I would just not recommend that. But again, it's that's something that you would have to weigh in on in an individual situation. Going down here further, we did just talk about the multiple listing service, whether or not is it going to be active, coming soon, or firm exclusive. The lockbox, you must get agreement from the seller if you're going to put a lockbox on the property. I would highly recommend that you not use a combo lock. The Supra locks are a safety valve, particularly if the house is occupied. You need to know who has gone in that property. Every now and then, I know it's hard to believe, but every now and then you'll have someone who will just decide they'll go show the property anyway, whether it's coming soon. If it's vacant, sometimes they'll sneak on in there, or sometimes they will try to go like early in the morning and not realizing somebody's in the house and scared the bejeebies out of the sellers. And yes, we've had that happen even to one of our agents. So you do want to try to use the Supra, because obviously you can have you can read those Supra boxes and find out the number of the Supra key that was used to open it, and you can track down if somebody didn't make their appointment and went into that property. Again, this the safest way to use it. Right here, other offers. The owner understands that the broker's responsibility to present offers to purchase to the owner for owner's consideration that terminates at the closing of the subject property or the expiration of this agreement. Do you know that you are responsible to present all offers even up to the day of closing? Is that not amazing? You would think, well, why would I keep on taking offers? Well, every now and then you're going to get one, but your responsibility is to present all offers even up to the day or a day before closing. However, you are not to present, you have no right to present an offer after this agreement has terminated. Can you? Sure. And you can, change this agreement with the seller. But just realize your responsibility ends at the last day of the term of this agreement. Marketing the property after accepted offers. The broker shall not continue marketing the property after an offer has been accepted unless requested in writing by the owner to do so. Well, the way our MLS is set up, that's done by basically by the status. When it's inactive, you're going to market it. When it's in coming soon status, it's being marketed, right? But when you change it to the coming soon under contract no show, that's another no show. You see, excuse me, under contract no show. Basically, the seller is saying, okay, take it off the market. I don't want to have anybody else in my house right now. I want to get to closing. But you can still take an offer during that time, even though you can't show it. All right, so that's the way the MLS is set up in our area. This mediation clause is important. The mediation, that's part of the National Association of Realtors process of doing things. They always get buy-in on being willing to mediate a dispute before you would take it into a civil court matter. So there are numbers of times that obviously we try to negotiate it before it ever gets there, which is a form of negotiation, excuse me, a form of mediation. There are times we do have to actually go to the board and do mediation with a trained mediator at the board. Again, to try to keep from clogging up the court systems, but also to keep down costs involved for the parties. Photography, when you pay for photography, professional photography to be done for the property, whether you pay or the seller pays, you do not own the rights to that photography. The photographer who actually did the work is the one who has the right to call it copyrighted, because it's their work. One of the things you have to be really cautious about is you do not ever take photographs off of a listing in MLS and then use them on your listing. Whether sometimes we see people who might have had a house listed for sale and then they put it back in for rent, and maybe they rented it through the buyer agent. Okay, excuse me, they want to rent it through their buyer agent. Buyer agents puts the pictures in and they think, well, why can't I use the same pictures? Because you don't have a right to. Just remember who has the right to those photographs. And basically that's, again, a teaching thing for, or educational value to your seller. Surveillance. This is a little different, which is strange to me in South Carolina than North Carolina on surveillance. I would have thought they would be more similar. This says the seller agrees to abide by any laws and regulations regulating audio and video surveillance of the property and persons entering the property, including agreeing not to use any surveillance in areas where persons have an expectation of privacy. The seller agrees that the broker may or may not disclose potential surveillance as broker deems necessary, including signage on the property and in advertising and marketing. Why would we have to have a seller's permission to say there's probably surveillance equipment in this house? I do not know that, but it's in that. Just be aware that it's in this listing agreement. Okay, that's we're not the one that puts the ADT sign in the yard or the CPI, whatever the other one is. We're not the ones that advertise that. They are the ones that have it in the yard. We don't. And I guess they're saying we can't put anything in the listing that says they have surveillance. One of the main differences other than that in this paragraph is we've been told that I believe it was federal law that the sellers can have video. They can watch what's going on when people are in their house, but they cannot have audio. They cannot record the audio. This basically is almost indicating that it is permissible, but it does say follow the laws and the regulations. So just kind of be aware of that. Again, here's your conditions that you may or may not change. If you're going to change anything, it has to be done right here. One of the things in South Carolina, they added, instead of having an additional signatures addendum, they have added 4 lines for owners to sign. So you can see there's 4 spots here. They don't anticipate 4 on all of them, but instead of having the traditional 2, now they have 4. And of course, down here is where you would put the firm and you obviously representing the firm. Now that is the only listing agreement in South Carolina. Okay. They have multiple agreements to buy and sell, but they only have the one listing agreement. So be aware of that. There is not a separate listing agreement for vacant land as there is in North Carolina. All right, we've talked about those 2 forms. We've talked about the canopy forms. Let's go on down here. The residential property disclosure. We could camp out on here about I'm sure an hour or 2 on their property disclosure. You will note, first of all, the title, again, is different. The title is called Representing Property Condition Disclosure. And often you will see it referred to as the CDS. and I can't even say CDS. I always say CVS. I bought my pharmacy items at CVS for too many years. I guess it's hard for me to say CDS. Whereas I guess that's really might be more appropriate because it's really the property condition report that's being disclosed. But be aware too, whereas in North Carolina, the seller has the right to put no representation if he just chooses not to disclose. And every now and then, a seller will just say, I'm not going to disclose that. But remember, if they say they're not going to disclose it and you know it to be a material fact, you have to disclose it. All right. South Carolina does not say that the owner has the right to just not disclose if he doesn't know anything. It's if you know something, you got to tell it. If you don't know it, don't tell it. And you can put no representation if you don't know. But if you do know, you cannot say no representation. That's a little bit different instructions on South Carolina versus North Carolina. Again, you want to make sure that this is presented to all buyers, whether it's a for sale by owner needing to present it, or if you're representing a buyer, you must make sure that for sale by owner gives you the property disclosure. Today we're talking about listing and talking with sellers, so make sure you have that. And please have it done to be able to attach it to your listing. Oh my gosh, that is the nicest thing. How many years I've chased down disclosure statements so that I can have it at the time of writing an offer. It's really important, not so much that the buyer knows all the details and agrees with all the details, but it's important that they have it in their hand when they actually make the offer to purchase. Okay. Again, on the bottom here, you're going to have signatures of the owner and the purchaser that they acknowledge the receipt of a copy of this page. That's all it is. They are acknowledging they got it. They are not saying they agree with it. They're not saying they disagree with it. They're acknowledging that they got it. That is on the bottom of each of these pages. Now, let me show you another funny little trick. Not trick, it's a funny little way they have done things. Where you see here, it's page 1 of 5. All right, so you go 1 of 5, you got 2 of 5, you got 3 of 5, you got 4 of 5, you got 5 of 5, and you got that page. There's 6 pages. There is no number on that 6th page. It is not 6 of 6. It's not anything. There is absolutely no number. It is it's referred to right back up here. Let me show you right in here. They added this about 2 years ago, I think it was. Whether the property is subject to governance of a homeowners association, which carried certain rights and obligations that may limit the use of this property and involve financial obligations. If there is, you're going to check yes, and see that little star right there? That star says, if yes, owner must complete the attached residential property disclosure statement addendum. For years, there were 2 separate documents. You know, when you got the property condition report, it was one document, and then you had to go get the addendum. Well, to simplify things for you, they have placed the addendum with this particular form so that you don't have to go find it. You just can discard it if it's not needed. You can turn it in, and we know it's not needed if you've got no checked here. But the important thing is you have the forms that you need it when you need it. So if it's yes here, then you're obviously going to scoot right on down here to that addendum. And this will obviously be part of the disclosure. It's really important that if there is an HOA, that the seller know the information. The seller obviously knows what he's paying for an HOA fee. He needs to know if there's more than one HOA. This form only alludes to one, but we have a number. For instance, Baxter has 2 HOAs. They do not have one. In that case, I would suggest that you might want to have a second addendum. You might have to print that a separate form out to write the information about the second addendum. We had a buyer years ago now who got out of a contract because there was a second HOA and he wasn't informed. But it wasn't a major amount of money, but he just didn't like the fact that he wasn't informed. And so he got out of the contract because it hadn't been disclosed. So I would say that you might want to make sure if there are two HOAs, such as in Baxter, where they have a master HOA and they have I think it's mostly the condominiums because there's a condominium association. So make sure that you know if there's more than one HOA. And I would note that right back up here where it asks if there is one. You might want, obviously you want to make a note of this, and you might even put it on these lines here that a second HOA is involved. This is not too much different from your North Carolina property disclosure. It covers basically the same things, but look here, the very first thing that they address is the water supply and sanitary sewage disposal system. Boy, there are people right after my own heart right now. You know how I've had to harp on this for so long. And you know, we have our own little form. It has to be filled out in South Carolina, just like it does in North Carolina. And keep your finger right there. Let's scoot on down here and look at it a moment. This is your, wait, where is it? There it is. Your septic or sewer and water, your agent discovery form. This is not the seller's disclosure. The seller's disclosure is what we're just now looking at. This is you verifying and confirming what the seller is telling you. So help me, it hasn't been 10 days ago that we had the scenario that the seller said that they were on septic and sewer, and they were not. They were on well. I mean, not well. They were on. They were not on the city sewer. They were on septic. And I'm thinking, how many times have we still have these sellers that not know because they don't know, you know? And so anyway, back to my little agent discovery form. This is for verification to help keep you out of trouble. And thank goodness it was my buyer's agent discovered it. And before they got to closing, they were able to correct things because our agent had done our verification form and found out they couldn't find anywhere where the county was paying for it. So all that to say, this is just your form. All right. If you are the listing agent, you're going to check right here. You're going to put the property address. It a lot of times doesn't involve anything but one telephone call. Or if the seller can give you a utility bill, that's even better. When you look at the utility bill, it's going to say on the utility bill, which they call water bill, it's going to say water if it's only water. It'll be stormwater and it'll be sewer services. There's charges almost duplicated of the water. So make sure on that invoice that they get, that they call the water bill, is there anything itemized that would say anything to do with the sewer system? If there's not, you've got to do some work. You then have to go beyond looking at their bill. Hopefully you don't, but if you do, you have one telephone call. You make the telephone call to the county to confirm one way or the other. You want to call the county where the service is given to hopefully the sewer service. If there is not anything listed for it, you know, then there's only two other options. There's only one primary other offering, and that would be a septic system. There is also something called a community service. And if they have a community service, the seller is going to have an extra bill every month. And the seller is going to know that. The seller is going to know if he pays I think when I moved to town years ago, we had a community service, and it was like $67, if I'm not mistaken. If he's paying $67 a month for a service, he's going to know that. So he should be able to tell you if he has a community service. So that's why I say the only alternative basically is your septic. If the seller tells you that it's on sewer and you've called and there's no record of it being connected or being either available, sometimes it's available and the seller had opted not to connect, but you need to find out if it's either available, you need to find out if it's connected. And if it's not, you immediately go down to this section here. You go down to the bottom. You've got to know then your route is to be able to find a permit for that septic that the seller is saying he doesn't have. So the way you find it out, you look at these are your options to find out. You're going to call the environmental health services, not the utilities. The utilities is up at the top of the page. You're going to find out what the utility service is. Down here is where you're going to find the permit for a septic system. The important thing is that you find out, when you find out that septic system, you need to find out how many bedrooms that septic system allows. It seems to me like it's 2.25 people per bedrooms. And I kept thinking, where's the quarter person? But anyway, I believe it's 2.25 in one of the counties that we deal with. So if it only is designed to handle 3-bedroom occupants in 3 bedrooms, you cannot sell it as a 4-bedroom. That's misrepresentation. The seller is going to be living with you because he bought it as a 4-bedroom or 5-bedroom or 6-bedroom. And he doesn't understand, he doesn't want to understand why you can only advertise it as 3. But you persist that you cannot advertise it any more than that because you've got a permit. The permit departments will often tell you that they don't have records beyond 6 years. That is not totally true on septic systems. We are told by state law that they can never archive septic system permits. They can and do archive other permits after 6 years. So there are ways, and they need to be able to archive, most likely on microfiche or maybe it's on the cloud nowadays. They are to be able to find that septic permit for the life of the septic system. So we've had this situation where our seller was told by the environmental health department person, and make sure you get that person's name and what department right here that you called and what date you called. You want to get that information, because if a buyer's agent comes up and says, I don't know why you couldn't get it, I called and I talked to so-and-so, and here's the permit that says only 2 bedrooms and you're advertising 4 bedrooms. Oh dear, you've got a problem. So does your seller have a problem? So this little scenario has been ongoing as one of the #1 problems for, gosh, I bet it's been 10 years now. But our office is doing so well in being able to keep down costs to the buyers and the sellers and the E&O by doing this verification. So just know that if you're the listing agent, you verify this information. The seller has disclosed it on the property condition report. So you sign this saying, this is what I found out, and you must put it in your file. You don't have to give it to anybody, but you know the information. If you happen to be the buyer's agent, however, and you find out, like that buyer's agent who was able to find a septic permit, she signed here and she did disclose to her buyer what she found out here. Because see, the buyer is not, they're just receiving the disclosures. So That's the reason only the buyer is going to sign if you are the buyer's agent. Otherwise, in this scenario, you're the listing agent and you would only sign that. This is just the explanation of what I gave you in writing. Now back up to the property disclosure. There it is. The first thing that they want you to address is the water and this sanitary sewage disposal. You're just going to describe where the water and where the water is coming from. You're going to what the water disposal. Is it a septic or is it sewer? Is it private, corporate? What if it's an HOA? If the HOA takes care of it. One of my agents a few weeks ago had a terrible time with HOA verifying that they actually took care of the bill for it. So you might have that issue sometimes. The pipes, you may or may not know what the pipes are in there. Seller may or may not know. If they don't, then they can check. Unknown. You're going to see very often in our area, you're going to see PEX or you're going to see polybutylene. The polybutylene, there was a class action suit, oh gosh, many years ago now, maybe 20 years ago. And so home inspectors often will point out that this has polybutylene. It doesn't mean that the system is going to fail tomorrow, but home inspectors do point that out, that there has been a class action suit and the buyer has a right to do inspections and do investigations on it. I happen to have been one of those homeowners who had that polybutylene that did fail, and all the damage in the house. And in fact, I had to have my house replumbed twice. Once with the homeowners, and then once as a result of the class action suit. So I know it does happen, but it doesn't happen all the time, and it's generally from the fittings, you know. So there's no way of telling sometimes when it would happen, but there was a rash of it back in the 90s. We have not seen that much lately. PEX piping, we're seeing some of the same problems because PEX is the product that they designed after the polybutylene. So you might see that they have PEX piping. You rarely are going to see too much copper. You're mostly going to see the plastic, you know, the PEX, the polybutylene. Now the roofs, the foundations, the basement, the structural components, make sure that on the roof system, one of the things that added recently to this property condition report or disclosure was this right here. The approximate year that the current roof covering was installed, the approximate year the house was built, and during the ownership, any known leaks or how it was repaired would be noted right here. This was because we were seeing people say they had new roofs. Well, they wanted to be clear as to when the new started already. Plumbing, electrical, heating. Again, this is pretty, there's a lot of things in here. So make sure that anything that the seller knows, he does disclose. If he doesn't know, he's okay to put no or no representation. Termites in South Carolina. One of the contingencies in their agreement to buy and sell that goes beyond due diligence is that CL 100, which is the report that says there's no wood destroying organisms in the house. So make sure the seller understands they're not going to be hiding that and not have consequences. So if they know of any wood destroying organisms, or if they know of any problems, they need to go ahead and get it taken care of, because they're going to have to take care of it to sell the house. The damages, I see right here, dry rot or fungus, that dry rot, that's going to have to be repaired. That's in the agreement to buy and sell. Now the seller, if he refuses to do it, the buyer can accept it, but it's the buyer's right to terminate too, and get and then he would be in the position to possibly get his earnest money back. We can't say that he would get it, but just make sure the seller understands they don't play games with the effects of wood destroying organisms in South Carolina. And that is still a part of the contract. Remember when we had those seller paid repairs, that was part of it. But now all the seller repairs are gone because they're using the strict due diligence contract. but that contingency is still in there about the particularly the termite damage and wood rot as a result. Again, if there's a termite bond, the bond typically is put on the property if there has been a previous treatment of termites. A company that has done the treatments will put a bond on that property. Most likely the termite bond is going to be transferable. There is a fee, and it requires the owners, whether new or the new owner, they would be required to have an annual inspection by that company, and that company would warrant that they would not have any problems with termites. If so, they would treat it. Okay, so if there is a bond, make sure you know what it is, what the transfer amount is, and again, that might require you to make a telephone call or get the seller to call and let you know. Obviously, if there are any known pest infestations, you might as well disclose it because it's going to be found out. So don't cause mistrust by not disclosing that. Again, these are things that are not too much different than what you have done with your North Carolina property disclosure. I would say one of the things that you want to address is the flood insurance that's covering the property, or FEMA. That would be anything to do with any FEMA claims. Chandra, you might want to take a note of that, because with Columbia, they had some major flooding about, was it 3 years ago, maybe now? And there were FEMA claims obviously during that time. So I don't know of most of the properties in this area, the area of South Carolina that we cover, that we have too much of that. Flood insurance is not going to be required unless the floodplain touches the house. If it's across the backyard, and who wants a soggy backyard, but you're not going to have to pay for flood insurance most of the time. And I should say most of the time you don't, but you do have to disclose if you're in a floodplain. There is a form, imagine that, a form that explains about the floodplain and flood insurance and in South Carolina. So you may want to put that in your package if you feel like it would be a benefit to your seller. Down here, this is the next where you have the buried oil tanks and the storage tanks and all, or if you have other environmental concerns such as lead-based paint, asbestos, radon. I think I told you all not too long, a couple of weeks ago in the North Carolina, I said about the radon brochure. I really should put this in the stack of paper, shouldn't I? There's a real, I think it's a nice brochure. The South Carolina brochure to me is a little bit more user-friendly and informative than the North Carolina brochure on radon. Radon has not been one of the things that you have heard about for years. It has become more predominant in inspections in the last 5 years, I guess. So you might want to make sure that you have that in your pre-listing package, or the things that you want to get into your seller's hands so they are aware of the radon tests that may or may not be done. This would be about rentals. This is obviously we've got a lot of people buying for investments these days, and so you want to make sure that you're disclosing what needs to be disclosed in that area. If your property is in an HOA area where they are limiting the percentage of rentals in the neighborhood, this is the HOA's way of trying to protect sellers, because lenders are not going to lend over certain percentages of the homes in an area being rental for rental purposes. You may have gotten an offer from an investor who has that as a contingency in the contract, the offer to purchase or the agreement to buy and sell, where they were saying that it's contingent upon X number of rentals being able to be allowed in that neighborhood, or there's no rental cap in that neighborhood, because that's the only way the HOAs have been able to fight back of all the investors buying so many houses in a neighborhood. And because that really affects every seller in that neighborhood, and even more so if it's a condominium. That seems to be the biggest culprit, but it's also affecting single family homes too. So kind of be aware of that and find out if your seller knows of any cap you might want to start asking about an HOA, ask the HOA management company if there is such a cap for them to know. So that's pretty much one thing you might want to take a look at here. This is page 5 of 5. So the purchaser acknowledges prior to signing this disclosure. Make sure it is prior to them signing the disclosure, although the other pages say they're signing only in a receipt that they've got it. Now they're saying they're saying they have received all of this in addition. So I don't know where we would get in what would happen out of that discrepancy, but you as an agent, just be aware of it. Okay. All right, let's scooch on down here. We've got a couple more forms that we want to look at. Oh, I told you there was a form about flood insurance, and I did put it in here. So again, this is a good form for it's educational, informational disclosure, and you can't ever disclose too much, I think. So make sure that if you have any anticipation of it being in a flood plain, you want to make sure about the flood insurance. And if you need to settle a dispute or a misunderstanding of whether or not flood insurance is required, you're going to get a flood an elevation certificate, I think it's called, done by a surveyor. And a surveyor is the one who would actually have the final word as to whether or not that property is going to require flood insurance. So you might have to do that sometimes. Oh, these are two good, there are three actually, good resources to find out about flood plains and flood insurance. Now, some of you might be selling in some 55 and older communities. Everybody knows that Sun City is a 55 and above active adult community. Everybody knows that Four Seasons is. We know that Treetops is. We know it because we sell properties. However, every listing that goes in MLS has to have this statement, and it has to come from the HOA or someone on the board. It cannot come from you. Why they can't have a blanket, I do not know. The rule is any listing that you have in a 55 and above community, in order to advertise that it is a 55 and older community, you must have this statement. Recently, I believe it's Carolina Lakes, one of our agents had to get this, and she had everything geared to go active on one day, and the day before, because she had it coming soon, the CMLS checker got her and called her, or not called her, emailed her that she didn't have that 55. And I was, well, she really got in gear to get that thing done, because you can't just get the HOA to sign it on a moment's notice, but she got it done. And but that reminded me to remind you that you are going to need that on every listing, not there's no blanket. We've already talked about that. We've got I think two more forms we want to look at. Please do this little simple form or a form, something similar to it. Utilities. It is so helpful to a buyer not to have to hunt to figure out who services the utilities in a particular listing. If you're under contract as a buyer's agent, ask the listing agent to provide it for you. If you're the listing agent, go ahead and have it provided, have it ready to provide. Attach it to your listing agreement in the MLS. Get the seller to tell you who he pays his electric bill to. Who does he pay his gas bill to? Who does he have propane gas? And who is the fuel supplier on that? Down here, these are a couple of things to be considered. Trash service. Not every community has trash service as part of their taxes. Some people have to pay extra for trash pickup. It's not included in the HOA. It's not included in the taxes. It is an individual account. Well, a person needs to know that. You know, paying an extra $65 or $55 or whatever a month, or an expense and a quarter, that can make a difference in some people's budgets. And so you need to let them know if there is a trash service that is beyond what they would expect not to have in certain neighborhoods. There are people who've never paid for tax service. It seems to be a little, I keep saying tax, I mean trash. I think we've got more neighborhoods that you do have to pay for trash than that don't, but just be aware of that. The cable companies, which cable companies have lines in that neighborhood? If you're in a ways out, but a little bit more remote from the in-town properties, certain services might not be available. It's important that if the seller knows, the seller discloses, and then you make that available. When I put property tax down here, remember about 3 or 4 months ago now, MLS has now put 2 new fields in. I think one of them is called city tax paid, or no city tax paid. That means only the county. So therefore you can put the tax location as the county, which is the default. If there is a city involved or township involved, you're most likely going to need to put in MLS that the tax location is the city. I live in Matthews. I have to pay a Matthews tax. I do not pay Charlotte. I have to pay a Matthews tax, but I also pay Mecklenburg. I don't have to tell anybody I pay Mecklenburg because that's the default. If there's extra, which in my case is Matthews, somebody else's might be Weddington, somebody else's might be Monroe, whatever. If there is a tax that beyond the default of the county, then that's where you want to put that. There's a field to put it in MLS now, which I'm so glad, because we have so many problems with that qualifier of the city. And just know that if just because it's in Mecklenburg County, it very likely is not, taxes are not paid to Mecklenburg County only. So be aware of that. That's why that's on there. Sometimes sellers don't even know, quite honestly. So you want to get try to get a copy of their tax bill if you can. Now, the only other form that we would recommend for a buyer of a property in South Carolina, I do not require it for the listing side, because there are very few services as a seller that you're going to need to put on the professional services disclosure. This is again a form that was designed by the attorney in Baxter, so that we could have a worksheet on what services were going to be ordered and who was going to order them. It was important because if you are going to order them, you have to have the permission of the seller to order them. Otherwise, you can be held responsible for the bill. We had probably 2 or 3 years ago now, where we had an agent who ordered a structural engineer to come out and evaluate a property, and didn't realize he was going to be charged $385, I believe it was. And the seller said, the buyer said, I didn't order that. And the agent said, but the report said that you had to get a structural engineer to evaluate. And the buyer says, well, I'm not buying that property and I'm not paying that bill. And the structural engineer took my agent to small claims court, and he got paid $385 because my agent had ordered it and did not have anything in writing that gave him the permission to order it. And the buyer denied ever saying that he did, and he may not have. I don't know. So all that to say, this is what that's for, to protect you if you order inspection reports. Again, you won't have to have very much from the seller's perspective. I did put it in there so that you're aware of it. The one thing that you want to note here, again, is the surveys. This is to remind you to get a survey from the seller if the seller has one. If the seller doesn't, then you don't have it. But if they do, you might want to take a look at it and to see if there's any encroachments that you see. Of course, it a lot depends on when the survey was done too. You know, the survey could have been done 20 years ago and there's been fences added. And excuse me, or there may be an encroachment of some other way. Somebody might have added concrete driveway. And yes, we have that happen often. They add a concrete driveway and they just don't quite get it on their side of on the side of their lot, you know. So look at surveys. If you're representing the buyer, please don't let them buy a property and spend $500,000 and not get a survey. What is another $500 at that point, right? So this just explains it a little bit more about the surveys. Now, I didn't put it on here because it's a lot disclosure. The only disclosure that, in addition to these forms that we use in the office, is something called a land lot disclosure. It is a 2-page document that basically asks the seller what the seller knows about the property, so that when buyers agents start asking you as the listing agent certain questions, you're going to have the answers. It basically tells you the answers you need to be prepared to give to a buyer's agent. So you might want to take a look at that little lot disclosure if you're going to be listing a lot or land. Selling land is a little bit different animal than selling residences. It really is, because there are a lot of things that you kind of have to look for. And if you do have a lot listed, even more reason to have a lot disclosure is when you get an offer to purchase, which they call agreement to buy and sell general. It's number 4, it's form 330. Wouldn't hurt you to take a look at that one either. They have a lot of provisions in that offer that you and your seller need to be aware of. And again, that land disclosure gives you gives you time to find out those answers to some of the questions or the contingencies that are in there. So, well, I have enjoyed seeing you come and go. Way to go, Robin. Come and go. And Monica joined us.
Thank you for your patience.
Yeah, no problem, honey. It's always a pleasure to see all of you ladies. And thank you for joining me today. If you have any questions, give me a call. Do you want me to send you all this group of forms?
Yes, please. Yes,
Yeah,
please.
that would be great.
Would you like that? Okay.
That'd be great.
I will email them out to you. And thanks again for being with me. Take care.
Is this recorded? Will this be posted?
It's recorded. I don't know if it'll be posted. You want me to send you the full recording?
Yeah, that'd be great if you don't mind.
I can do it.
Thank you so much.
It should be ready. It usually takes about 30, 45 minutes or so. So this afternoon, I'll send it out to you. Okay.
Okay. Yeah. Thank you.
All right. You are certainly welcome. Thanks for joining us. Good to see you.
You too.
Take
Bye-bye.
care.
Bye.
Bye. Now let me see if I can get us out of here. You are welcome, LaShondra.